Is recording.
All right, thank you so much. Good afternoon, everyone. Welcome to the appellate court. I am Judge Cradle, and I am sitting today with Judge Alexander and Judge Levine. This is the matter of JASMIN Luna, AC 43097. This is a virtual argument that's being conducted on the Microsoft Teams platform. It is being live streamed on the Judicial Branch's website, YouTube channel, and the recording of this argument will be posted on the branch's website. To the extent that there's any protected information involved in this case, it should not be disclosed, and I would remind counsel not to divulge protected information during the course of their argument. To make sure we can hear and see one another, I would ask everyone to introduce themselves, beginning with the judges, followed by counsel for the appellant, and then counsel for the appellee. I am Judge Cradle.
Judge Alexander. Judge Levine.
Counsel for the appellant.
Yeah. I'm sorry, I'm Lila Haswell.
Catherine Bear from the state of Connecticut.
Okay, thank you very much. I'm able to hear and see everyone. If during the course of your argument you cannot hear or see everyone, please bring it to our attention. I'm going to ask that everyone mute their microphones when you're not speaking, just so that we don't have any feedback. You must also keep your camera on at all times, just to so that we know that you're still present, and the judges will do the same. If we have any questions, we will raise our hands. If you don't notice us doing that, then we'll just jump right in and ask the question. Everyone should be mindful that this is a court proceeding and everyone should conduct themselves as if they were present in the courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of their time for rebuttal. The appellant should let me know before you proceed how much rebuttal time you would like, if any. Judge Alexander has in fact agreed to keep track of time, and she'll notify you when you have 2 minutes and 1 minute remaining, and also when your time is up. You've each received instructions, I believe, prior to today's argument. Does anyone have any questions before we proceed? Okay, hearing none then, Attorney Haswell, you may proceed. You're also on mute.
May it please the court, my name is Lila Haswell from the Chief Public Defender's Office. I represent JASMIN Luna in this case. I'm going to ask for 4 minutes rebuttal.
Okay, go right ahead.
Okay, we raised 4 issues in this case. For this argument, I would like to focus on the first 2 from my main brief, which would be the state's second and third from its brief. The first issue is whether the trial court improperly excluded the motorcycle driver's toxicology report, which showed that he had a number of substances, mind-altering substances in his system, including marijuana, benzos, opiates, oxycodone, and amphetamine. And the second being whether the improper admission of the decedent's death certificate was testimonial hearsay. Turning to the first issue, the exclusion of the toxicology report violated Ms. Luna's constitutional right to present a defense. At trial, the defendant argued that Luna was not on her cell phone at the time of the accident, that the driver was going over the speed limit, that he could have maneuvered around Ms. Luna's car rather than falling over and sliding right into it. He also argued that Ms. Luna was almost in the driveway when the accident occurred, and pictures of skid marks show that the motorcycle drifted to the right towards Ms. Luna's car prior to impact. The excluded evidence, the driver's tox report showing that he had those 5 mind-altering substances in his system, fit into the narrative because it supported the theory that he was impaired. It would have allowed Ms. Luna to argue that his impairment caused him to lose control of the vehicle and fall, or caused him to make a rash decision. Yes.
Counsel, I'm looking at page A55 of your brief, and it says it's positive, obviously for cannabinoid, but other substances as well, but got meds when admitted to mid-state. So with respect to it, how did the court err if there's no way to say that this, especially all the other ones, maybe marijuana, but you don't even have any level. But the other ones seem to be as a result of medical intervention.
Well, Your Honor, I'm not sure that.
Your Honor,
Yes.
I'm getting messages from the recorder. I'm not sure if we were recording. Want to please wait 1 second?
Sure.
Thank you. I apologize, Your Honor. We are all set.
Thank you.
Right.
Go ahead.
And so, counsel, if I said brief, I meant your appendix, but 855 in the medical records say got meds when admitted to mid-state. And then secondarily, on some of the other pages, I believe that the specimens that show that were again from hours after the incident as well.
Some of them, Your Honor, some of them were given at Hartford Hospital. I mean, answering your second question.
Right. I think I'm looking at A59 collected on May 21st, 17 at 04:46 hours. So that would be nearly 12 hours after.
Some of them, yes, Your Honor, some of them were, but for example, the oxycodone, if you look at page A59, the oxycodone screen shows that it was performed at Mid-State Medical Center. But so that would be one of the ones that was done 12 hours before. I'm sorry, no, that would have been one of the ones that was done within an hour of the accident. He was, Mr. Tardif was brought to Mid-State Medical Center, and then from there he was life-starred quickly to Hartford Hospital. So some of the, I mean, at least the oxycodone, I think the trial court erred in determining that it was done 12 hours after, because it was done within an hour.
Which page are you looking at?
Page A59.
I see the same result. Am I reading it wrong?
If you look, it says halfway down the page, it says oxycodone screen.
Mm-hmm.
And then ordering provider, specimen information, component, oxycodone screen, and then underneath comment, for medical purposes only, performed at Mid-State Medical Center, Meriden, Connecticut.
But it still, I think, says that it was collected on 5/21/17 at 04:46. It's all within that same
Well,
screen.
I'm not sure. I don't think that is accurate because.
But isn't that just demonstrating the point that without someone to interpret these, it would have just caused confusion to the jury? Because they would have no way of knowing what was given for medical treatment. He could have been given that painkiller for medical treatment. And to simply say that I'm going to introduce these records and the jury has the common sense to figure it out, I don't think is sufficient for a court to allow these in as evidence. Don't you think that these needed to be interpreted? I guess I'm getting to my bottom line question.
Well, maybe it would have been helpful for them to be interpreted, but I don't believe that they needed to be because, I mean, for one thing, as far as whatever he was given in the hospital goes, the state had access to his medical records, and they could have rebutted this evidence by asking that those records be put in to show whatever medication that he was given.
But that would be the opposite, because you were trying to say or the defendant was trying to say they were relevant. So wouldn't you have to establish that they were in fact relevant, that these were substances that in fact would have contributed to his actions during the accident?
I would say that it was the state's burden to determine to let the court know whatever, if he had been given any meds.
So that's your argument, that you can put in the records and then the state would need to rebut them?
Yes.
Okay, thank you.
You're welcome.
I have a question, if I may, just on that same point. Does your answer to Judge Alexander, does that also relate to the what is apparently marijuana? In other words, is it your view that the mere fact that there may have been marijuana in his system in and of itself should have been admissible?
Yes, Your Honor. Yes, thank you for pointing that out. The marijuana could have been, even if the court was concerned about the fact that those the substances might have been given in the hospital, the marijuana certainly was not. And the case law is clear that that jurors know, it's common knowledge that marijuana can negatively impact your driving. So, or the jurors know the effects of marijuana, or they've either used it themselves or heard about it. So it is at least, I think we've included in our brief that if nothing else, the court could have allowed the jury to hear about the marijuana.
Right. So let me follow up on that. Do you accept the proposition that it is your burden to prove the relevance of the offer of just the marijuana? I'm going to question you now only about marijuana.
Okay.
Do you agree that it was your burden to prove that the existence of the marijuana in the decedent's system was relevant to the case or to the defense?
Yes, it would be our burden to show it was relevant, but I would also suggest that it's not much of a jump to show relevancy. The evidence only needs to show any tendency to support the argument, and just the very fact that he had marijuana in his system would support it, and the jury would understand that it may or may not have impacted him, but at least it does to some extent support his position, her position.
Now, let me ask you this, and the record is not clear on this, so I'm going to pose a hypothetical, and understanding the record may not be clear. Supposing that the decedent had smoked marijuana 25 or 30 days prior, and that it was still in his blood or his system, but that if an expert were to testify the expert would testify that after a period of days, well before the accident, there would have been no continuing impact of the marijuana. Are you with me?
Mm-hmm.
Supposing that evidence existed, would you then concede that relevance would not, under those circumstances, have been established? Do you understand my question?
Yeah, I do. I do. If I could just take a moment to think about it.
Sure. Of course.
If I think, Your Honor, let me just make sure I understand it. If there was clear proof that the individual hadn't smoked marijuana after 25 or 30 days ago. Is that what you're asking?
Yeah. He smoked marijuana well before the accident, but I'm hypothesizing that it was, there's evidence it was still in his blood, but that the effect on his driving, his reflexes, etc., if the hypothesis is that it would not have affected his driving, his reflexes, etc. Would you agree then that there would be the evidence of the marijuana in the toxicology report would be irrelevant?
Well, I would, as long as we know for a fact that he hadn't smoked any marijuana in the last month or so.
Okay, so do you believe that it was your burden to demonstrate that whatever marijuana was in his system was still having an impact on his driving, his reflexes, etc.? Do you accept that that was the defense's burden?
Well, no, I'm not accepting. I don't accept that it was the defense's burden to prove it. But even if it is, there is plenty of evidence to show that to bolster the idea that he was impaired. For example, the fact that the very fact that he laid down the bike, which was treated as though it was the right thing to do, is actually not. I mean, as I imagine the police and the state must know, it probably would just make things worse. And they speculated that he did that, but he could have very well have just fallen. And
well, you're not suggesting that's evidence of impairment, are you?
Well, I think it bolsters the idea that he was impaired as opposed to making a rational decision. I mean, it appears that he also went right towards the car as opposed to kind of trying to drive around it. I mean, and also the other issue is that the police and the state never really investigated whether or not Mr. Tardif had illegal substances that would have impacted him.
Counsel,
even though he had a lot.
You wanted 4 minutes, is that correct?
Yes, Your Honor.
Rebuttal. I'm going to give you an extra minute just because we had that delay. So I'll put 1 minute on, but you're 1 minute out of for your 16 minutes. Okay.
Okay. Thank you. So, I mean, I do think, yeah, it would have been better if there was an expert, but just the fact that there was not doesn't mean that the evidence shouldn't have been admitted for what it was worth. I do think that it was really important. It was very important to the defendant's case. It was probably, I mean, it would have made a big difference to them to the defendant's defense. So Because I only probably have 30 seconds, I'm just going to say we're asking.
Yeah, it's about time.
We're asking that the conviction be reversed. Thank you.
All right, thank you. Attorney Bear, when you're ready.
Thank you. May it please the court, my name is Catherine Bear. I'm a senior assistant state's attorney from the Appellate Bureau at the Chief State's Attorney's Office. Here on behalf of the state of Connecticut, appellee in this matter. It's black letter law that it's the proponent of the evidence to establish both a foundation and relevancy to admit evidence here that laid with the defendant who sought to proffer this evidence. And Judge Levine's hypo makes the state's point, which is that even if we have levels, which we don't have, of the amount of these substances, you would not only need the time of ingestion, but the quantity and some kind of level to make a connection to render it relevant to the disputed issue in the case. That is, it would only, of course, have gone to causation. It would not have gone to negligence. And I would note, today, so far, we've used the term cannabinoid, which is the term that's in the medical report. And we've colloquially, the court has used the term marijuana, but we don't even know, our case law talks about marijuana, which I understand cannabinoid, is the larger category. CBD is also one form of a cannabinoid. THC is, of course, the product that's found in marijuana. So this just, I would actually suggest that puts a hole in the defendant's argument, or any argument that the defendant has, that at a minimum the marijuana or cannabinoid, which is the proper term here at issue, would have come in, because that term in and of itself needed explanation. Again, and as Judge Alexander pointed out, we have the notes in the records themselves indicating a recognition that the decedent in this case, Mr. Tardif, had received medication after upon being transported to the hospital, and the state's review is consistent with Judge Alexander's with respect to the collection of the sample. But again, in the absence of any expert witness to help explain these records, we simply don't know. With respect to the defendant's arguments concerning the laying down the bike, there was testimony from the expert witness, the state's expert witness, the reconstruction expert Lieutenant Cosette, that was an evasive maneuver, so that was evidence in the case. Nothing prohibited the defendant from presenting her own expert or reconstruction expert regarding both either the speed or the skid marks or what that represented. And that's why ultimately, even if this evidence had come in, which the state submits it could not, because we don't have these levels, we don't have the time that it entered the body, we don't have any explanation of how these substances, being complex in nature, interact together, even assuming that the cannabinoid is THC and in fact marijuana, how that would interplay, since it's not simply, as our case law has only recognized alcohol and marijuana alone. But even if it came in on the issue of causation, here, the rest of the state's evidence was simply too strong. In other words, it wasn't, you would have had to, the state submits, you would have had to have evidence indicating that Lieutenant Cosette's testimony concerning the approximate speed of Mr. Tardif, which was 34 miles per hour, and in this 35 mile per hour zone, the length of the skid mark, 67 feet of combined skid marks and gouge marks, that was somehow way off base. If, for example, the defense had come in and been able to present an estimate of both an intoxication level at the time of the crash, plus perhaps an expert who could counter the state's evidence regarding Mr. Tardif's speed and say, oh no, actually he was going 90 miles per hour, Cosette was way wrong, he wasn't simply going 35 miles, then maybe you could have had an ultimate effect on the verdict. But ultimately, at the end of the day, it's the state's position that under any evidentiary or constitutional standard of harm, it's ultimately harmless because of the rest of the state's case.
I have a question for you, Attorney Bear. Do you concede, and use marijuana, you concede that it is a matter of common knowledge? I do hear an echo. I'm not sure why.
Oh, I'm sorry.
Yeah. Do you concede that it's a matter of common knowledge that cannabinoid is a general reference to marijuana or something akin to marijuana?
I would agree that marijuana is one type of cannabinoid.
Right. So in other words, in simple English, would you agree that it's probably true that a member of the jury would probably think, hey, he was high. He had been smoking marijuana and he was high, or something akin to that?
The jury might make that inference if they were just presented with these records alone. But of course, as Your Honor's earlier hypo highlighted, if it had been ingested a certain amount long enough in the past, there would have been no impact or no effect on his ability to operate.
Right. But since there's no evidence in the record, I believe, as to the time, how long in advance of an accident the marijuana or the cannabinoid would continue to be in the bloodstream. Here's my question. Why isn't it correct that merely offering evidence of the cannabinoid in the bloodstream in and of itself would be enough to establish relevance, and then the state would have the burden of rebutting that by demonstrating that there's a lack of sufficient expert testimony or proof? In other words, once the jury hears, I'm going to use colloquial language, if the jury hears that this man was high, why isn't that at least minimally relevant to his defense? And I'm sticking with marijuana now. Let's put the other stuff aside.
Sure.
Why isn't that just enough in and of itself?
Because we don't know that he was high. That's an unfair assumption based on these records. It simply shows the substance in his was detected as a positive value of unknown quantity in his urine. We don't know that he was in fact high, and I would submit actually that inference would be highly unfair because we don't know the time at which it was ingested and the exact quantities.
All right, so you believe the defendant had the burden of demonstrating relevance by either expert testimony or additional evidence that would have demonstrated that degree of cannabinoid would have had an effect on the decedent.
Absolutely, Your Honor. Yes. And just a quick note on the 4-104 argument. You know, the state raised it below, and I presented that argument on appeal simply to make the point that these documents were not self-authenticating. In other words, this was not a situation where the state had stipulated or agreed that they would come in. The state did object to their admission. Therefore, that is what shifted the burden to present either the fact that they were self-authenticating or a witness through whom they could be entered as business records, which, by the way, was never stated below on the record. But assuming that everyone was operating functionally under that sort of understanding that that's what these types of records would fall under, it would then still fall on the defendant as the proponent to establish those hallmarks. I'm happy to answer any questions on any of the other issues or on this issue as well. I don't want to stray too far, given that my opponent only had the opportunity to talk about that first issue. But if the court has no other questions, I would rest on my brief for the remainder of my argument. Thank you. I would ask this court to affirm the judgment of conviction.
Okay, thank you. Attorney Haswell?
Yes, Your Honor. Regarding the Judge Levine's question of what the defendant needs to prove about relevancy, I'm not sure it's possible to determine the impact of marijuana use to a certain degree, unless there's some type of behavior that shows that they're high or they're impaired. Mr. Tardif unfortunately had passed, so I'm not sure that it would have been possible really to determine how the marijuana or the other substances impacted him. So I think for what what the evidence was worth, the jury should have heard it, and the state would have had the opportunity to argue that it doesn't really go very far or prove very much. And the other issue is that Attorney Baer touched on. I would just note that the trial court ruled as to foundation. The trial court ruled on this issue on the merits. The court determined it wasn't relevant. It didn't. Attorney Schultz had subpoenaed the medical records along with somebody from the medical records department to come and testify as to that they were authentic. And I think he did what he could, and the court didn't ultimately decide this on foundation. It decided this on the merits. So I do think there was a foundation laid and adequately, and the court erred in not letting the documents in. So unless the court has any further questions, I don't have any further comments.
Judge Cradle, I just wanted to know if you intend to ask the parties to address the letter that we got from Attorney Baer about sealing some documents, I believe. I think we got such a letter today.
I did not get a final notification that we received one.
Okay.
So.
I see.
Yeah.
I did get an email indicating that she was going to be filing or intended to file a motion relating to certain medical records. I didn't know what the status of that was.
Right. After that, I did not receive anything else, so I wasn't going to mention it because I hadn't received anything.
Okay.
Thank you, though.
But we did receive your 6710 letter, which referred us to State versus Davis. Thank you very much for that, for the last issue. And Attorney Haswell, you received that as well, correct?
Yeah.
Okay, good. Thank you.
All right. Well, thank you to all the parties. We'll take this matter under advisement, and we stand in recess until 3 p.m. Thank you.
Thank you.
Thank you.
Thank you.